immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and advocates and licensed immigration attorneys come together to learn, exchange information, and stay current on U.S. immigration developments. My name is GB Satusa, and I'll be your host for today's session, Asylum in the U.S. Eligibility, Evidence, and Common Pitfalls in Today's Adjudication Climate. Applying for asylum in the United States involves strict legal standards and careful preparation. Applicants must demonstrate eligibility under U.S. law, provide credible testimony, and submit strong supporting evidence. In today's adjudication climate, even minor inconsistencies, insufficient documentation, or procedural missteps can significantly affect a case's outcome. The webinar will provide a clear breakdown of asylum eligibility requirements, evidentiary expectations, and common pitfalls that lead to delays or denials. Our goal is to help applicants, families, and practitioners better understand how asylum claims are evaluated and how to prepare in accordance with current standards. To guide us through this important discussion, we are joined by attorney Adriana Robinson. Attorney Robinson practices immigration law with experience in removal defense, asylum, and humanitarian relief. She also has strong experience in family-based immigration matters and T and U visa cases. Through her work, she assists individuals and families navigating complex immigration processes and advocates for clients seeking protection and lawful status in the United States. Attorney Robinson, thank you for joining us today. It's a pleasure to have you on our live stream.
Good afternoon. Thank you for having me.
Now, before we begin, a quick reminder to everyone watching, immigrationquestion.com is a public educational platform. The information shared today is for general educational purposes and does not constitute individualized legal advice. If you're joining us on Facebook, YouTube, LinkedIn, and other platforms, welcome. We encourage you to subscribe and share this session with anyone who may benefit from a clearer understanding of asylum law. Attorney Robinson, to start with the foundation, can you explain the basic legal requirements for asylum in the United States and how adjudicators evaluate whether someone qualifies under the 5 protected grounds?
Okay, so the basic requirements for asylum is past persecution or well-founded fear of future harm, and then it has to be on account of one of the 5 protected grounds. So that would be race, religion, nationality, political opinion, or membership in a particular social group. And the persecutor either has to be the government or it has to be someone that the government will not or cannot control. And you also have to apply for a 1-year deadline. So it is a strict deadline, but there are some exceptions that we'll talk about. And also, so adjudicators, they often ask 3 main questions. So they try to identify the persecutor. So who caused the harm? And another thing they try to do is identify the type of harm that was caused. And they also try to establish nexus. So nexus is super important, and many people are able to show that they received persecution in their country. However, they fail to establish nexus, and without nexus, there is no claim to asylum. So what nexus is basically a connection between the persecution that was received, the harm that was received in your country, and connected to one of the five protected grounds. So let me give you an example. Let's say you're very vocal about your political opinion in your country and you receive a beating. You need to be able to connect that beating to your political opinion. And they do this by asking you questions and through evidence. For example, um, why did they beat you? What were they yelling at you about when they were beating you? Those are things that help show nexus. So it's important to be able to show all of these things in order to qualify for asylum.
Now, attorney, in today's adjudication climate, what types of evidence are most critical to establishing a strong asylum case? And how has the expectation for documentation evolved in the recent years?
So in addition to a completely filled out I-589, which is the form used for, it's the application for asylum. So on top of that, you need a detailed personal statement, which is it's a declaration. It's something that you have to recount the events of what happened in your country and why you're scared to go back, as well as country conditions, medical or psych reports. If you have trauma, it's good to get a mental health evaluation, um, or it could be police reports. If you received physical beating, then if you have medical reports, that could be used as well. Social media posts, photos, and it could also be affidavits from witnesses, friends, family. All of those things are great to show that you qualify for asylum.
And how has the expectation for the documentation evolved in the recent years?
So the standards have become stricter. So now officers and judges alike want to see more specific, individualized evidence. So uh, I like an affidavit and country conditions. It's not going to cut it anymore. They want to see photos. They want to see medical records. They want to see any kind of government document that you might have. They would also need to see uh, evidence from witnesses. It could be family members or friends, and it has to be individualized. So, articles, uh, if it's individualized and it's specific to your case, then it would be a good thing to add. So, they have been a lot more stricter. Also, um, the old style declarations were a lot shorter and contained a lot less details. However, declarations now need to contain a lot more detail. They need to recount all of the event that actually happened, date, times, place, locations. Who were you with? How many people hurt you? What did they look like? How old were they? Those kinds of questions, if you ask yourself those kinds of questions while doing your declaration, you'll have a better chance.
Right. Now, attorney, credibility findings can make or break a case. What common inconsistencies or presentation issues tend to raise red flags during asylum interviews or immigration court hearings?
Okay, so there's inconsistencies between case documents. For example, it could be border notes or the CFI, the I-589, the declaration, and your testimony. They tend to cross-reference all of these documents. And let's say you um, are not able to recount the events properly, then that's something that goes to credibility. So remaining consistent all throughout your case is super important from beginning to end. And some presentation issues, as I mentioned, is not being able to recount events properly, maybe shifting timelines or not describing core events in detail, or giving like a general description of what happened, or what kind of um, trauma or attack you received. That's also a presentation issue. So those things go all towards credibility, and the officers and judges analyze them.
All right. Now, many applicants struggle with the 1 year filing deadline. What exceptions exist, and what mistakes often prevent applicants from qualifying for those exceptions?
Okay, so there's two exceptions. There's two statutory exceptions. So it's uh, a change in country conditions as well as extraordinary circumstances. So um, change in it could also be a change in personal circumstance, for example, lawful status. So there's often the case where you have lawful status. Um, the biggest example would be TPS. You have TPS, it was terminated, you've been here over a year. So being able to show that you had lawful status and now you don't, and you're scared to return to your country, you meet all of the other elements for asylum. So that would be something that you would need to document and submit. And it could help you overcome the 1 year deadline, as well as a change in your country condition. Maybe the condition in your country has worsened. Um, you would need to be able to show how it would affect your case specifically, and how it would affect you specifically and individually. And you may be able to overcome the 1 year deadline. There is also extraordinary circumstance. So it could be maybe you were a minor when you came into the US, and you are now the age of majority and you want to apply for asylum, but you've been here for over a year. So those are things that can help overcome the 1 year deadline, or sickness, illness, disability, death of a family member. All of those things are able to help overcome the 1 year deadline if you did not file within 1 year. Um, and so a lot of the biggest mistake is waiting too long after meeting that exception. So it's best to get on it right away. For example, if you reach the age of majority and you wait another 3 years to apply for asylum, then you just might not overcome the 1 year deadline. So it's important to get on it right away when your circumstances have changed, whether it's personal or an extraordinary circumstance.
Now, how are current enforcement trends and procedural changes affecting asylum applicants, particularly those in removal proceedings versus those filing affirmatively?
So, affirmative asylum trends, a big one that I've noticed is, and that I'm sure most attorneys have noticed, is so asylum interviews are still ongoing. However, the decisions in asylum have paused. Um, so, they are not issuing affirmative asylum decisions at this very moment. So, that's one trend, as well as a 1 year deadline. They are asking a lot about the 1 year deadline and focusing questions on the 1 year deadline and the exceptions. Um, and the interviews are scheduled faster. So you have less time to prepare a supplemental package or evidence to turn into the asylum officer. So those are the current trends I'm realizing with affirmative asylum interviews or affirmative asylum. Um, Now, defensive asylum trends that I'm seeing, and one of the most problematic, are pre-termissions. And so that's basically a pre-termination of your asylum without giving you a chance for a hearing. Um, there are ways to prevent a pre-termination or pre-termission. So it would be filling out the I-589 completely, as well as stating the complaint. Make sure that you actually qualify for asylum and make sure that you're stating your claim completely. You're supplementing your I-589 with an affidavit, with witness testimony, with photos, with whatever you have. So those are the greatest asylum trends I'm seeing as well. And also, there's a greater emphasis on consistency. So all of that goes to credibility as well when it comes to consistency. So make sure that you're referencing your CFI, your asylum interview, your actual I-589 when it was filed with USCIS, your affidavit. Make sure everything is consistent.
All right. Now, Attorney, looking ahead, what practical steps can asylum seekers and their attorneys take early in the process to avoid common pitfalls and strengthen their case from the outset?
So, as I mentioned about pretermissions earlier, so it's basically a termination of your asylum claim without giving you an opportunity for your hearings. So, some of it can be prevented by just filling out the I-589, remaining proactive. Especially for clients, I always recommend not to wait last minute to receive a hearing notice or a deadline for them to hire an attorney. You always have to hire an attorney when it comes to asylum, especially now. And the standards are so strict. So that's what I would say to anyone who's interested in applying for asylum and might qualify. Do not wait to hire an attorney, because then you might just be scrambling to pick up your documents, all evidence that you want to turn in. So it's best not to do that. And so I also recommend keeping all of your documents throughout your entire case in one file.
All right. Thank you so much for those detailed insights, Attorney Robinson. This has truly been an insightful session so far. For those watching, asylum cases are highly fact specific and require careful documentation, preparation, and consistency. Early legal guidance makes a significant difference in how a claim is presented and evaluated. If this is your first time joining us, immigrationquestion.com is a networking platform where users can ask immigration related questions with participating attorneys. We're also proud to announce that immigrationquestion.com is Triple B accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Robinson, based on your extensive experience, how does a platform like immigrationquestion.com help immigrants and immigration attorneys like yourself?
By giving us resources. I think now more than ever, we need to rely on resources and we need to rely on each other, especially as an attorney. I tend to rely on other attorneys for knowledge. Maybe they've experienced something that I haven't experienced. So it's great that you're giving attorneys as well as potential clients an opportunity to retain resources.
Thank you so much for those thoughts, Attorney. Now, before we move into our live Q&A session, I have one final question. Given the heightened scrutiny and evolving evidentiary expectations in asylum cases today, what early warning signs suggest that an applicant's case may require additional preparation or expert support before filing?
So I always recommend, especially like I said, the standards are stricter than ever. So I always recommend having an attorney review your case, especially now. You don't want to run the risk of filing for asylum when you die or you may not have a claim.
Right. if you're just joining us, we've been speaking with Adriana Robinson, Esquire, on asylum in the US, eligibility, evidence, and common pitfalls in today's adjudication climate. We are now moving into a live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Please drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible. How long does it usually take to get a decision on an asylum case now? Attorney, if you can still hear me, we've got you back.
Okay. Okay, perfect. Thank you.
No
In
problem.
USCIS or court, both of them can, especially now that affirmative asylum decisions aren't being issued. So right now we don't know when the pause will end. So it's really hard to say, honestly. If you're in court, it could even take a couple of years, and that's if pretermission isn't an issue. So it has to be analyzed on a case-by-case basis. So I'm sorry, it depends is my answer.
All right. All right. Thanks, attorney. Right. Is there a kind of evidence that is strongest to show I have a well-founded fear of persecution?
Yes. So once again, I've mentioned having a strong declaration, remaining consistent throughout your entire case, as well as if you photos of if you have articles, if you have witness testimony, as well as medical records or psych reports or anything to show why you're scared, to be a subjective and objective standard. So you have to be scared of persecution, but you also it has to be reasonable, basically. So both things you have to show. So I would say declaration, medical records, psych report that you are able to get.
All right. If I'm detained while my asylum is still processing, what will that do to my case?
So you would be able to continue your case while detained. You would be given a hearing date. So that would be an option, and that's if your pretermission isn't an issue. So that's a possibility.
All right. All right. Now, attorney, as adjudication standards continue to evolve and scrutiny of asylum cases remains high, preparation has become more critical than ever. Considering today's climate, what proactive measures should asylum seekers and their attorneys take at the very beginning of a case to reduce the risk of delays, requests for evidence, credibility challenges, or denials?
So making sure you're cross-referencing all documents on all the case documents. So CFI, if they've already had their asylum interview, maybe FOIA the asylum interview, or try to request the asylum interview. just so you can see what was answered, how it was answered, the dates used, making sure that you have records and copies of everything that has been submitted and filed. All of this is important.
Thank you so much, Adriana Robinson Esquire, for sharing your knowledge and practical guidance today. Your insights helps applicants and families better understand what to expect and how to prepare effectively in asylum cases. And to everyone who joined us for this important discussion, thank you. You can always visit immigrationquestion.com to ask immigration related questions and stay informed about upcoming live events. If you'd like to revisit today's session or share it with others, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. Join us next week for another live conversation on key immigration topics. Until then, stay informed and stay connected.
Thank you.